Thank you for joining Jackson Lewis as we take a closer look at the employment law trends and tactics sure to shape 2023. This installment is one of 12 concise, field-specific podcast episodes that are part of our annual forecasting favorite, The Year Ahead. We invite you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series at whichever platform you turn to for compelling content.
Good to be here with you, Jason. I guess a good place to start is lawyers love acronyms. We've been hearing a lot about CCPA, CPRA. What should listeners know?
That's right, Joe. The CCPA, the California Consumer Privacy Act, has been in effect since January 1st, 2020. But we're hearing even more about it now due to the effective date of the CPRA, the California Privacy Rights Act, which just passed on January 1st, 2023, and the CPRA amends the CCPA. The CCPA is really the first comprehensive U.S. consumer privacy law, and while it's intended to provide consumers, a term that's broadly defined as any California resident, greater information and control over their personal information, it also comes with a pretty heavy compliance burden for businesses or organizations who are subject to it.
Okay, so who has to worry about this, and what are the obligations?
Well, Joe, in general, the CCPA applies to any entity that does business in California, collects personal information of California residents, and has either a gross revenue of $25 million or more, whether that's inside or outside of California, collects information of 100,000 California residents, or derives 50% or more of its revenue from selling or sharing personal information. We should note that the CCPA may apply to your business even if you're not located in California, and the term personal information is defined extremely broadly under the statute. It's also important to remember that the CCPA may be applicable if you are a service provider to a covered business, regardless of whether or not it has direct applicability to you. Under the CCPA, as amended by the CPRA, businesses have some key obligations, including providing a notice at collection, posting a privacy policy on the company's website that outlines their online and offline practices concerning personal information, and individual rights, responding to individual rights requests, and training for those employees who are handling individual rights requests. There's also a requirement to address service provider agreements and data security. What's really important for us to remember is that while the CCPA is currently getting the most attention, there's similar consumer protection statutes passed in other states like Colorado, Virginia, Utah, and Connecticut, with more likely on the way. Notably, as we currently stand, and unlike the CCPA, none of those laws apply with respect to employment data.
Jay, you mentioned individual rights, and not to throw another acronym in, but the GDPR, the General Data Protection Regulation, the EU, has similar rights, and the right of erasure being one of the popular ones. Understanding that the CCPA, CPRA is fashioned as a consumer protection statute, and that it grants several rights to consumers, and you can't see my air quotes, but they're there. How does that play in the employment space?
Well, you're right, Joe. It really is a consumer protection statute. But since the definition of consumer includes applicants, employees, and contractors, the CCPA also applies to those individuals. While the CCPA originally included a carve-out for employment-related data and only required that employees or applicants or contractors be provided a notice at collection that set forth the categories of personal information that you were going to collect about them and the purposes for which that data was going to be used, as of January 1st, 2023, that exemption expired, and now applicants, employees, and contractors are afforded additional individual rights, including the right to know, right to delete, and right to correct their personal information, which frankly only gets things more complicated when you think about the types of data you need to maintain and potentially share about your employees. For example, how do you handle a request to delete personal information if you have a legal or business obligation to keep it? How do you address customer or client requests for DEI data, which may be sensitive information as defined by the CCPA? Or in the performance review context, how will you be able to handle a request to correct a review which an employee does not agree with? These questions, unfortunately, don't always have clean answers, and the fact that draft CCPA regulations do not currently address employment data only further complicates this issue.
Okay, so what can employers do now?
First, you've got to determine if the CCPA applies to you. I can't tell you how many clients or prospective clients have come to us and said, we need to worry about the CCPA. And in essence, the first question we ask is whether or not it's even applicable. And in many instances, it may not be. But if it does apply to you, then you'll need to take some steps for compliance. One, get counsel involved. That's always going to be the first recommendation. You got to determine what personal information you're collecting, from where, and what you're doing with it, a process generally referred to as data mapping. And then you've got to determine what notices and policies you need to get in place and start doing so in short order. While we're still operating under draft regulations, the CPRA's effective enforcement date is July 1st, 2023, and that's rapidly approaching. So, Joe, I know we've been talking a lot about the CCPA or CPRA, but much of the privacy space deals with the vast amounts of data being collected and processed. What are you seeing on the technology front related to data collection and use?
Right, lots of data. Do you remember when we were in the COVID trenches helping what seemed to be every firm client? Much of that work involved looking carefully at various technologies to help our clients get through the pandemic and the avalanche of health and safety protocols. We helped clients grapple with temperature screening equipment that used facial recognition technology. We helped them set up secure remote work environments when there were lockdowns. We helped them evaluate social distancing wristbands and explore new apps that tracked COVID testing and vaccination status and so on. All of these technologies had one thing in common. They collected lots of personal information. During that same period, and increasing more rapidly now, artificial intelligence, or AI, is being more broadly adopted as organizations urgently search for technologies to help solve serious challenges that the company faces or seek a competitive advantage in their business. Whether that challenge or advantage is a pandemic, improving their recruiting efforts, growing sales, improving efficiencies, or whatever, the solutions are found often in new technologies. And we're seeing that algorithms and machine learning technologies have been around for decades, but factors like computing power has made it more accessible. So AI is being infused in, it seems, every application, and is being used in what seems all industries. Oftentimes, those applications affect an organization's workforce. And yes, it too is collecting a lot of data. It'll be important for organizations to consider how data is handled before, during, and after the latest AI tech is deployed. Getting answers to questions like, do we need this data for the application to be effective? Are we working with good data? Who should have access to the data? Can it be de-identified? Should it be de-identified? How long do we need to hold the data? And others. These are all critical to addressing data privacy and other concerns.
So, Joe, how are employers using AI?
So there's lots of examples, Jay. Here's a couple. A popular application of AI in HR is for recruiting, sourcing the best pool of candidates, evaluating those candidates through an algorithm that may process a significant amount of data provided by the company, as well as what's received from the potential candidates, perhaps while analyzing a candidate's performance, their facial expressions during a video interview. The application's results can inform decision makers, should we hire or not, but there are risks, such as disparate impact that might result in hiring or screening out otherwise qualified candidates. Another example, beyond direct HR applications, a business might be looking to AI to help solve business problems. Think, for example, an AI-powered dash cam that's being installed in company fleets to drive efficiencies, lower costs, and to also maintain driver safety. The AI in those devices enhance their ability to quickly identify whether the driver is falling asleep or maybe looking at their phone. Importantly, in operation, this technology could be collecting a significant amount of personal data, including employee conversations, their location, and perhaps even their biometric data.
So there's certainly a lot here, Joe. Is this just the Wild West, or are there laws governing the use of AI in the workplace?
It's kind of both. Thinking back not that far back, in 2019, the Global Organization for Economic Cooperation and Development, OECD, adopted principles on artificial intelligence. Many of these are finding their way into regulatory activity here in the US. Back in 2016, the EEOC had a public meeting on big data in the workplace, big data, with some of those efforts culminating in 2022, currently non-binding technical assistance document addressing algorithmic decision-making in the ADA. The California Department of Fair Employment and Housing currently is working on regulations on automated decision systems. There's an Illinois law that went into effect in 2020 to regulate the use of AI-powered video job interviews. Most recently, the New York City adopted a measure that regulated automated decision tools. And that was set to be effective this year, or at the beginning of this year, but has been pushed to April. The White House put out some guidelines. This is not an exhaustive list. So in general, it's important to think about the kinds of principles, since the law is developing, that are being considered and adopted. They include things like providing an understanding of the AI system, notifying people when they are interacting with those systems, and then enabling them to challenge the results if they're adversely affected. In the New York City measure, covered entities generally cannot use an automated employment decision tool unless they've undergone a bias audit and made it public. So it looks like the Wild West may be tamed quickly. Let's switch gears a little bit and look at another facet of technology, Jay, surveillance. As we've seen, COVID has led to a lot of changes in the workplace, including remote work. Additionally, advancements in technology have created opportunities for employers, significant opportunities to monitor and track their employees. What are you seeing in this space?
Well, absolutely, Joe. COVID changed the world and the workplace. And you asked earlier, but no, I certainly don't remember COVID, or I'm trying to forget it. Let's put it that way. It's also created challenges for businesses who are dealing with retention, hiring, and productivity issues. Obviously, productivity is a significant factor for businesses. So as organizations look to address employee productivity concerns, many are turning towards electronic surveillance to monitor employee performance, whether that's on-site or working remotely. This might include video conferencing, key logging, GPS tracking, use of computer or other video cameras, or even some of the AI technologies you touched on earlier. It's really been a fascinating time in this space as our group has gotten some pretty interesting inquiries regarding the limits of employee surveillance. Let's just say at the outset that no company should be monitoring their employees 24 hours a day, 7 days a week, regardless of location. If that's where you're starting your idea, you should probably stop right away.
Yeah, exactly. I mean, the law is interesting here because it can really depend upon the type of technology and where people reside. A good example, as you mentioned, is remote work as a consequence of COVID. I mean, employers really are still struggling to adapt. We've both worked on projects where there are smart cameras being proposed to verify who the employee is and that where they're supposed to be working remotely. And that involves sometimes taking a face scan and potentially collecting biometric information, which triggers some pretty significant laws. Another example comes from a memo that the NLRB General Counsel issued in late 2020, and that examines employers' use of any electronic monitoring or automated management and its impact on employees' right to engage in protected concerted activity. I'll leave it there for my labor colleagues to expand on protected concerted activity, but it's important that in order to avoid these kinds of legal compliance issues, before any technology is rolled out, employees really have to think more carefully about, among other things, what exactly is the technology doing? I mean, we saw this in COVID where devices were doing things that clients didn't realize. What information is it collecting? How is it processing that information? But beyond those, Jay, what additional concerns are there?
Yeah, Joe, there are definitely a number of additional concerns. The big one for me is the employee relations concerns, especially in the current environment where retention and hiring are challenges that just about every business or industry is facing. For me, you need to carefully consider the balance between the legitimate interests of the company and an employee feeling as though Big Brother's always watching. There's also a concern that you're going to be gathering information or other evidence or material that you otherwise wouldn't have a good business reason to know, whether that's medical or health information, disability-related information, or even evidence of something like a domestic violence if you're recording video or audio in somebody's home. So it's an area that needs to be assessed before you as a business just jump in.
Yeah, exactly. I mean, when it comes to these areas that we've been discussing, Jay, privacy, data security, surveillance, one thing we want to also talk about is litigation risks. What are we seeing there?
So great point, Joe. We're seeing a significant increase in privacy-related claims and only anticipate this trend is going to continue into the future. In particular, we're seeing claims related to how businesses contact individuals, whether that's under the TCPA, the Telephone Consumer Protection Act, or the Florida Telephone Solicitation Act. Claims related to the collection of information through a website visit, whether that's through session replay technology or the use of the website's chat functionality. A lot of those claims are being brought under the California Invasion of Privacy Act. We're seeing claims under the Video Privacy Protection Act, as well as continuing to see numerous claims filed under the Illinois Biometric Information Privacy Act, or BIPA. We're also seeing privacy claims under state and common law related to data breaches, the improper access or acquisition of personal information.
Well, it's fascinating. It sounds like we better get back to work. So that's a wrap. I hope that's been helpful. Thanks for listening.
Thanks, everybody.
Thank you for joining us for the Year Ahead 2023 Special Edition podcast series. Please tune in to the next episode where we will continue to tell you not only what's legal, but what is effective. All of our Jackson Lewis podcasts are available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.